Hey, fighters, here we are, episode 23, Governmental Immunity, Protecting the Guilty. Round 2. I got this stellar panel again with Chris Desmond, our chief appellate attorney, Tommy Waun, Paul Doherty, our managing attorneys, and yours truly, here to talk a little bit more about governmental immunity. The fact of the matter is, when we're talking about governmental immunity, some folks get that a little skewed along with sovereign immunity, a federal law concept. So what's the difference? How is it the same? What?
Yeah, they're just two completely different standards. So there are instances where we sue people under Michigan law, and then there are other instances where we sue governmental actors under federal law. Those usually come under a federal statute called 42 USC 1983.
USC is what?
United States Code. And so these are the kind of cases that a lot of people think of when they think about suing the government. Your false arrests, malicious prosecution, wrongful imprisonment, excessive force against police officers, the George Floyd type cases, Patrick Lyoya type of cases.
So sovereign immunity is a federal law. In essence, it's governmental immunity for the feds.
Governmental immunity is just a different standard. So a lot of times you'll hear in federal cases, they use the terminology qualified immunity instead of governmental immunity. There are different showings that we as lawyers have to make to be able to beat immunity in a federal case versus a state case.
And it makes it harder.
Yes.
For the average person, it's not the same standards it would be if it was a citizen suing another citizen.
No, and many of the same things that we talked about in the prior episode that apply in state law, apply in federal law too. The government gets to automatically go up on appeal. They get to slow cases down.
Docket, baby.
They get to bring motions for summary judgment more often. Judges get to be more involved in these decisions instead of juries. So all of those same things apply.
Were you surprised at all in the last episode when Doherty actually made a good point?
No, not...
Oh, you can be honest.
Managing partner Paul Doherty? No.
But he said the king can do no wrong, Paul. And what that's a concept that literally we talked about in law school.
Yeah.
How does that figure into what Chris is talking about right now?
It's just a continuation of that archaic rule. I mean, you're talking centuries ago. The king in England could not be sued, no matter what he did wrong to somebody.
Right.
And somehow that made its way to America, and it's taken root here, and it perpetuates its ugly self.
All right. Ray versus Swagger. We talked about that a little bit. Here's the setup, ladies and gentlemen. This poor young man, he was 13, Chris. He was trying out. He was right before his 14th birthday. He was an incoming freshman at Chelsea High School.
Yeah, first day of school at Chelsea High School.
And so because, of course, when you're trying out for a team, you got to do what the coach tells you to do. And he is an incoming freshman along with a couple others, and then the folks who had run cross country before. And this coach, Coach Swagger, he was one of those guys. He wanted to show everybody how great of a runner he was, right? So he ran with his team, and he was going to lead them and do all this stuff. Well, what happened was it's 5:30 in the morning. Of course, they got there at 5:15, pitch dark at the time, and they start running, and they run a particular path that takes them along, not just a roadway, but a sidewalk. They came up to a traffic light, which was red for their direction of travel, green for the cross street, which was a highway in the
US 12.
US 12.
Yeah,
I'd forgotten
Michigan
that,
Avenue. Yeah,
and
55 mile an hour speed limit.
They saw a car coming from their right to their left, and some guy apparently was about to or did touch the the pedestrian button to try to make it go white for him, but it wasn't. It was orange, stop. And coach yelled, Chris?
He said, no, run. So this student does the responsible thing. He hits the button to cycle the crosswalk, and the coach says no, knowing that there's a car approaching, and directs this group of about 19 students to run across Old US 12 while there's a car approaching at 55 miles an hour. They're
From
in the dark
right to the left.
and not a single student is wearing reflective gear because the coach didn't ask them to.
So coach is instructing these kids, ordering them, if you will, as Chris and I argued, to break the law, cross the street against the light. And by the way, he ran across the street on a red too. He admitted.
In front of his students.
And guess who's left behind, guys? The freshmen, because they're freshmen. So the two freshmen, I think there might have been others, but the two freshmen both got hit by this car. And luckily for kid number one, he got glanced and luckily kind of just flew and somehow didn't. And poor Kirsch got hit center pretty much on the grill, Chris. And I know he went up on the car and he was in a coma for over a month, and he is significantly impaired. Thanks to Michigan auto no-fault law at the time, he got the best of care. He was in the hospital, I think, Chris, for just shy of a year or some crazy.
Had to relearn how to speak, how to walk,
eat, do everything. But Kirsch, to this day, he's my Facebook friend. So Kirsch, what up, buddy? And his mom, Jackie, unfortunately, his dad passed a year or so ago. But just an incredible story of survival. And now we talk, Chris, about the lawsuit. You want to sue the school district, but you can't. Why can't you?
Well, there's no exception that applies to the school district here.
Right.
Because it was the coach who ordered him to do it, and that's not a highway, a sidewalk, a motor vehicle. It's none of those exceptions that apply to entities like we were discussing in the last case.
Yep. So we got to sue the coach, really, and that's it. This case, Chris, was started in 2009, 10-ish?
12.
Okay. So by then, gross negligence, when Tommy and I first started out, and Paul, we were talking about it, our first cases, was really no big deal. It was a big deal.
It's a gigantic deal. Yeah.
And the reason why it's such a big deal in the 2010, 2000 time frame up until Ray versus Swagger is because so many judges, and good judges, okay, judges that we all know and love, throw out cases on gross negligence and say this isn't enough without ever going to a jury. And we were facing that.
Well, and by the time we were dealing with the Ray versus Swagger case, the concept of proximate cause had changed in governmental immunity.
Tom, what's proximate cause?
It's the foreseeable result of negligent conduct.
Okay. So when we have to prove, and you proved just like you did in Saginaw, by the way, Tommy won $5.8 million verdict up in my home county of Saginaw recently in a great case. Congratulations. You have to prove what in order to get to point of asking for money?
In just real basic terms, you have to show that whatever the negligent conduct was, it caused the injury.
Okay.
In other words, you hit somebody with a car and they die, that caused the injury.
Got it. So in other words, if you hit them with a car, but they weren't injured and they had a heart attack 5 minutes later.
Or yeah, if you get hit by a glancing blow by a car and you already had a really bad leg injury and the car didn't affect your leg injury, you can't sue for the leg injury because the car crash did not cause the leg injury.
Got it. So here we'd have to prove gross negligence of Swagger and that the gross negligence was the THE proximate cause. Now, back in the day, going back to our last episode, here we go. Chris, you got to go review that last episode. It was really good. The fact of the matter is we talked about gross negligence wasn't a big deal. And then what we hadn't really mentioned yet, that it was the proximate cause. Guys, when we first started in the 80s and early 90s, right, it was a proximate cause. Every other case, all you had to prove it was a proximate cause. Even though the Governmental Tort Liability Act, GTLA, that Chris was talking about last time, said the proximate cause. And you go, Johnson, it's the same thing. You would be right. And that's what the courts back then ruled. No one understood or appreciated that there might be a difference between and the. And then all of a sudden, the Gang of Four and the Engler guys get into the Supreme Court. Tommy, you were talking about that last time. Mm-hmm. How did they, all of a sudden, when they switched and ignored stare decisis, ignored precedent, and started going 180 degrees the other way, how do they now interpret the proximate cause?
A proximate cause can be a cause combined with a number of other different causes to lead to an injury. In other words, slippery road, driver negligence, the person who's crossing the road not watching, all of those things can play in, but as long as the driver's negligence is a proximate cause, one of the proximate causes, you can sue for that. The proximate cause means, at least the way some courts were interpreting, is the sole
or last
or only.
Most immediate. Chris, what was it?
Yeah, so the language that the court, this was at the Supreme Court in 2000, there was a decision called Robinson versus City of Detroit.
Oh, dear God. One of the banes of my existence. Yep. You and I have
talked. The discussion in my job interview with you over a decade ago was all about that case. But
it's horrible
in Robinson
case.
Versus City of Detroit,
horrible case.
They said, 14 years after the law went into place, they said, well, all this time we've been ignoring that the word the is in the statute. And so the proximate cause means the one most immediate, efficient, and direct cause of the plaintiff's injury. So in a normal case, it's not unusual for us to have, we might have 2 or 3 defendants in a case, and we might go to trial against 2 or 3 defendants, and the jury gets to sit down and say, this defendant is 15% at fault, this defendant is 50% at fault, and then it ultimately tallies up to 100. In governmental immunity cases, they got to a point where they said, well, you can't do that with a governmental defendant. If you're not the one cause, then there is no liability for a governmental defendant.
So what was happening when the 180-degree turn in the mid-90s took effect, what was happening is even if we as plaintiffs on behalf of the victims could get past a judge's gross negligence analysis, they were throwing cases out of court saying, this isn't this is the proximate cause, and certainly this wasn't the last one. So let me give you an example of, for example, Oxford on this very topic, because it applied to Swagger, Chris, and I want you to explain that. But in other words, obviously, Ethan Crumley shot many people that day. And the argument is by a teacher, well, I'm not the most immediate cause of shooting this student. Ethan Crumley was. And it's like, in any other case, like Tommy just said, you would weigh that, the jury would weigh that, and the jury could take that into consideration. Here, though, the difference is the fucking trial judges were saying, oh, this can't be because Crumley shot, and therefore they were throwing cases out of court, Chris,
well, and there's
without even going to a jury
and
again.
there's some crazy outcomes out there. Remember the Beals case, the lifeguard case?
Yeah,
So there's a lifeguard case. It's a residential facility for disabled individuals in Michigan, and the plaintiff was a young man who lived at this facility. He was using their swimming pool. The facility had entrusted one of their residents to be the lifeguard. And if I recall correctly, it's even worse because I believe that lifeguard, the reason why he was in the facility was because he had debilitating attention deficit disorder. So you've taken someone who has debilitating ADD and made them a lifeguard.
You don't need to pay attention doing that.
Right. So while this young man is swimming in the pool, the lifeguard is not in the lifeguard chair. He's playing football. He's talking to other residents at the facility, and this young man dies. What the Supreme Court said in Beals was the proximate cause
Justice Zara, by the way,
wasn't the lifeguard not paying attention. It was whatever caused him to be
drown
under the water. And
the
so
proximate cause was the water. No, the proximate cause can't. It's got to be related to the negligence. So it's not the water. The water wasn't negligent. The water was there. Somebody or something caused him to go under, right, or stay under. And so again, it certainly is a defense they could raise, right, and then let a jury decide that. But that's not what they did. They threw it out of court and said, under this scenario, it cannot be. Mm-hmm. So Ray versus Swagger, Chris. We now go. We win the motion for summary disposition at the trial court. Judge Kuhnke.
Yes.
And
well,
I remember
you must have been dealing with whether the driver of the car was the
driver of
proximate
the
cause.
Our client being comparatively negligent, Paul. I mean, they fucking threw, and they should throw everything up there, but they're now arguing right? So, but Judge Kuhnke, go.
Well, and they also argued because Beals came out while we were litigating Ray, this lifeguard case that I was just talking about. One of the arguments they made was even if the driver wasn't the proximate cause and Kirsch wasn't the proximate cause, the car was the proximate cause.
Did they argue the darkness was the proximate cause?
Right. I mean, they didn't, but they might as well have. Yeah.
And again, you guys we're lawyers being in the weeds. But the point of the matter is, the proximate cause or proximate cause, it has to be related to a person because it has to be negligence. So it goes negligence, proximate cause, injury. So the fact that there's water or a car or dark, that's not a person. So it can't be the proximate cause of anything. But in any event, so we won in the trial court. We won Judge Kuhnke. Judge Kuhnke's an amazing judge out in Washtenaw County, and she read through it and did it the right way. Court of Appeals, Chris. So it's now it goes from Judge Kuhnke in trial, and all she said was, defendant, you're trying to get out for governmental immunity. Screw you. You got to go to trial. Well, she didn't say screw you, but I did. So then we go to the Michigan Court of Appeals, automatic, because rocket docket, don't forget, guys, they have special privileges. So now no other trial, or any other case, you would go to trial and then go after trial, right? Depending on the verdict. But now we go in the middle of the case, go to the Court of Appeals. What do they do to us, Chris?
So first of all, the rocket docket term is a little misleading because it makes it sound fast. This is over a year after.
They get priority. Right. They get an automatic right of appeal where no one else in the fucking world gets it. It's rocket docket. Right. Stop it.
But what I mean,
who are you, Tom Waun, arguing with me? What are you doing? That's Tom's job.
The Ray family sits and they wait a year for us to get into the Court of Appeals, right, and actually have another court address it.
Right.
And in the Court of Appeals, the panel of judges that we drew was a fairly conservative panel, I guess
You could say.
to put it mildly. And yeah, they held that either Kirsch or the driver of the car was the more immediate, efficient, or direct cause of the injury, and that no jury could find that it was the coach. So the case was done.
Thrown out. So then, you know who? Chris Desmond.
And Ven Johnson.
And we appealed to the Michigan Supreme Court. And one thing that folks may not know, the Michigan Supreme Court, in the overwhelming majority of cases, they do not need to take a case. So the fact that the Court of Appeals did something to us, Supreme Court looks at it and says, I may not want to get involved in this issue. But they granted our leave app and said that they would allow us to argue. Was it up on full argument? Or
It was a mini argument, but yeah.
So in other words, they wanted us to argue in front of them as to whether they should grant leave. Yet another rule, like Tom mentioned in the last episode, that the Supreme Court, the Gang of Four, made up. So because they were in the majority at the time. At the time, I think they were 5-2 or 4-3, but I think it was 5-2 Republican at the time. And they made up this new rule that they didn't have to actually have full argument. In other words, we're going to jack you around to see if we even want you here to have an argument, which is fucking ridiculous. In any event. So, Chris, remember where we were when we argued that thing?
River Rouge?
Rouge High School. Now, and you hear this and it's like, your argument's going to be there. What a great place to argue a governmental immunity school case. And I was really kind of excited about it. Chris, like, this is weird, dude.
Yeah.
Right? We were up on a stage. It was like
We were in the auditorium, the high school auditorium, in front of all the students.
And I remember they had a pretty packed house. I couldn't believe like anyone would go. But the school district, I remember Sam Bernstein, his wife, and Ricky Bernstein was not a Supreme Court justice yet. He was there. Came and watched the argument on this. Is interesting.
Well, and they brought in a team of lawyers to work with groups of students. So they would break the students into groups of 10 or 15
and talk about this
and assign a lawyer to them to educate them about the case before the argument, talk to them about it afterwards.
Right. So we went, I argued, I should have let Chris, but whatever. And luckily we stumbled across, but what happened? What was the ultimate opinion, Chris?
Well, so there were a couple things that happened. First of all, the court said that, referencing what you said earlier, to be the proximate cause, you have to be a negligent human actor. Negligent human actor. And they specified you can't be water, you can't be a bullet from a gun, you can't be a car, you have to be a human being. And they said the Court of Appeals also failed when they looked at the term the one most immediate, efficient, and direct. Courts had been confusing that with the last cause. So what was the last thing in the chain of events? And they said here, the coach says run, but then the student chooses to run, and then the driver
chooses
strikes
to
them.
run.
Right.
When a coach orders you to do something, you choose to run.
So that was
when
what
you're a freshman.
Right. Incoming
13-year-old.
Yeah.
13-year-old. So that's what the Court of Appeals focused on. The Supreme Court said that's wrong. You have to look. Proximate cause doesn't mean what was last. It means what's the most foreseeable, which is what Tom was referencing earlier. And so they said you have to look at the circumstances, and a jury is permitted in this case to say that the coach was the bigger cause of the injury than the driver or the student.
Right.
And one of the things they focused on too was the fact that our kid was 13 years old.
Right.
So they said a jury should be able to consider who is it that's making the decision to run into the road here.
So that got, if you will, reversed. They sent it back to the Court of Appeals, who wrote a really snotty, as I recall, same group. But it was all three Republican, by the way. Wrote a really snotty, like, we don't want to do this, but we have to. It was Judge Boonstra, if I'm not mistaken. Is
Judge
it right?
Boonstra, Hoekstra, and Saad.
Not that you remember. So they wrote an opinion that was for us and say, we don't want to do this, but they're making us, basically.
And then they took it back to the Supreme Court again.
And then they said no. And then we went to trial. We were a week away from trial, and they paid basically their entire policy limit because they knew at trial they were going to get lambasted. So I took one of the greatest things, and I give Chris the incredible credit. That's the first time that's ever happened in my career. But what was really, I think, really rewarding and something I feel really good about is having the ability, the luxury, if you will. We spent so much time, so much money, and our clients luckily were able to afford, thanks to the medical care and so forth, to wait 7.5 years to ultimately get them justice. And what I loved about it, and I explained this to the Kirsches, and you were right there with me, Chris, they're literally changing people's lives now in the future. And I will tell you that in our industry, in the civil law, that case gets mentioned all the time as being kind of a beginning of a game changer. So maybe, guys, there's some help on the way. We now have a Michigan Supreme Court that's 4-3 Democrat. all that means is, to me at least, that Democrats, guys, under the law, those judges typically allow cases to go to the jury, let the jury decide, which is what last time I knew the 7th Amendment of the Michigan Constitution affords us. But I think what we're going to see is more cases coming up. And Paul and Chris, you guys were involved in one, the Champine case. That's a huge opinion. We just won another one in the Michigan Supreme Court. A little different issue, Paul. Talk about Champine and what that was about.
Norm Champine is driving down 696 in Macomb County. The highway roadbed is in complete disrepair. It's a Sunday morning. He's minding his own business. And as he's driving, a chunk of concrete comes through his windshield effectively at 70 miles an hour and blasts him directly in the face. To this day, he still doesn't have a set of teeth, and we're 4 or 5 years later. So in any event, we sue under the highway defect exception.
So you're suing who?
MDOT, Michigan Department of Transportation.
Because the roadway's
Defective.
maintained by them.
Yeah,
and
they
defective.
maintain it's defective. I mean, the police determined this chunk of concrete came off of the roadbed.
Okay.
So in order to sue the state of Michigan, one of the special rules is you've got to give them notice. And you have to give them notice in writing, in triplicate, in other words, 3 pieces of paper, given to the Court of Claims, given to MDOT, before you can sue.
Okay, just so we're clear, Paul, no other area of law other than med-mal do you have to give notice to a defendant about anything.
I'm about to sue you, so here's my notice.
So if someone wanted to sue you for malpractice, God forbid, never happened, I know. But if they did, they wouldn't have to give you notice.
Nope,
They just
file the
case.
lawsuit. File the lawsuit.
Thank
so
you. Go, please.
And it says you have to give notice within 120 days of the event. So instead of the paper notice, we file the lawsuit before the 120 days runs. It's on a piece of paper. It's filed with the Court of Claims, and it's given to MDOT. Well, MDOT initially responds and says, you didn't comply with the notice provision. In other words, you didn't give us notice before you filed. And we said, what do you mean? We filed and you got notice that way. Well, the Court of Claims agrees. The Court of Appeals agrees. But then the Supreme Court takes the case. And the Supreme Court reverses and says, of course, the complaint can serve as notice. You satisfied that element of your duty. The second piece of the case is, under highway defect, you have to identify the exact location of the defect. Well, given the nature of this case, Mr. Champine was blasted in the face. He drove a mile or 2 before he pulled over and the police found him. The police took the chunk of concrete, which was in his lap, full of blood. They closed the freeway down. They started walking the freeway with a chunk of concrete, and after about 100 feet said, this is crazy. There's, in their words, thousands of potholes. We can't identify this.
Which one it came from,
exactly.
per se.
Can't say.
But we know it came from the road.
Came from the road. There's striations on the concrete. It's obviously a piece of road bed. It's not from a bridge.
Okay.
So the next day, MDOT comes to the scene. They have they take possession of the chunk of concrete. They go with their crew. They start looking. They said, forget it. We're just going to order a total repatching of 5 miles of I-696 because it's so bad. But we can't say what pothole this chunk came out of.
Who cares which one it came
Well, the
from
court-
if it's the roadway that they maintain?
That's what we're saying right now. So now the Supreme Court has sent it back to the Court of Appeals on the exact location issue.
Right.
And that's,
We'll see where we're at.
we'll see where we're at.
I had a case, Ari, a good friend of hers, Mr. Rob Moser, I'll never forget, similar facts. He was downtown Detroit, right down the street from our office, you guys, on I-75 going south, and a huge piece of concrete fell through his windshield and crushed his chest and so forth. And I filed the lawsuit. I actually did notices. Okay, I didn't just file the lawsuit, but I did a notice, but I didn't know who maintained that part. Do I talk about the bridge? Was it the roadway above the bottom of the bridge? Was it a pot, but we thought it was the bridge, very candidly. So I sent notices to MDOT, Michigan Department of Transportation, Wayne County DOT, right?
Mm-hmm.
Whatever they're called.
Road Commission.
City of Detroit Road Commission. And so, and of course, one of the things they don't do, guys, is say, oh, by the way, that's our roadway. Tell the other guys they don't have to be Sue Johnson. They don't do that, right? They sit back and play their little games and hide stuff, hide the football.
And wait till all the time periods run.
And then claim that you blew the statute of limitations. Welcome to governmental immunity. So we then did it that way. And finally, after about 3-6 months, I got the other ones out, and it was whoever it was. I think it was, it was the state of Michigan. Then they filed a motion with Judge Colombo, I'll never forget this, and said his notice, he sent it to MDOT and not to the Court of Claims. Well, it literally just happened. This was a good friend of my daughter, Aries, and I wanted to take care of this kid, and I was trying to make sure the roadway was fucking fixed. So I sent it to the entity, and back at that time, we all did that. Plaintiff lawyers everywhere, they didn't just serve notice there, but they served the lawsuits on those guys. Okay? So then they bring this, and Rob's like, "Ben, what's going on here?" He was like, "Dude, I'm just telling you, this is how it's done. It's called the standard of care. It's what everybody does that does this kind of work because I'm trying to make sure the roadway's fixed." Come to find out, they say that's not good enough. They throw it out. Almost an identical issue, Paul. And so I have to look this young man, good friend of my daughter's from high school. I have to look him in the face and say, "Dude, well, you're the first case that they've ever ruled that what I did was wrong."
And they did change the law with that too, because before that case, the law used to be if the government wanted to say the notice in this case was deficient, they had to show prejudice.
Right.
They had to show this impacted something in the case. So like in Paul's case, for example, MDOT's got the chunk of concrete the day this accident
We did as well,
happens.
by the way.
So right, you're Moser.
And
same
everybody,
thing.
by the way, determined it came from the bridge, the underside of the bridge.
They weren't surprised by this lawsuit.
No.
They knew about it. They got to collect evidence. They got to
and
do
they
all
went
of
out
that.
and fixed it,
Right.
by the way.
So it used to be that in a situation like that, the court would say, well, it doesn't matter that they didn't, dot all the I's and cross all the T's because you knew what was happening. They changed the law now to say it doesn't matter if they're prejudiced or not. Strict compliance. The statute says you have to do this by this day, and if you don't, no matter what, your case is done.
Goes back to a question I asked Tommy, you episode 22, and that is that what the law is supposed to be? Is that really fair?
No. Yeah. And I was telling when we were off camera for a minute, when I first started practicing law in 1982, if something internally felt wrong to you,
Right.
there was always a way in the law to make it right, because the law was set up so that it was flexible enough that if something was wrong, it could be corrected.
We talk-
that lawyers and courts could correct it.
Don't put form over substance.
Exactly. And that changed with that Engler Supreme Court. That changed when they started saying, well, we don't care if this didn't prejudice anybody, but we're going to make you technically comply with this statute, even though there's no reason behind it. The notice statutes are there to allow the state to actually recognize there's a defect, that there's something dangerous, and to go out and fix it.
Right.
That's what the notice provision is in the statute for. And so once Ven in his bridge case tells MDOT, hey, you have concrete falling off a bridge, and they go and fix it, the purpose of the statute has been completely fulfilled and complied with. But this form over substance kind of law really took root with this Engler court. It was the first time, and it was distressing to me, just personally.
Right, because it's wrong.
It made me feel like the law always was right over wrong, but now it's substance over right, and it makes no sense.
So what we see on the Champine case, Paul, is it to me, it looks like the Supreme Court in its current configuration is kind of going back and saying in a weird way without saying, because I can't bring that case back for Robin.
Yeah.
Okay. And that's what I want our listeners to get. When they change the law, that means there's no case. When the law changes back, or if it ever changes back, you can't go back and get those other cases done right. They're just screwed. Okay, I can see my daughter shaking her head in the back, and I don't blame you. It was such bullshit. But it sounds, Paul, like maybe there might be a little loosening of some of those strings with and Chris, the Champine case.
Well, they said, notice is notice. And whether it comes in the form of a piece of paper that says notice or a lawsuit, it's the same thing.
Tommy, you had a Boyle case, right? What was that?
Well, the Boyle case is the one we talked about in the last sequence, where my client was a motorcyclist.
Oh, that's the stop sign case.
The intersection where the stop sign had been knocked down. The county knew it, and they decided to take their people and grade roads for a week before they replaced the stop sign.
Right.
And somebody drove through the intersection not knowing there was a stop sign, hit my client, and severely injured him.
We talked about last time that after the Engler court got involved, no, you couldn't do that because the stop sign's not in the roadway. On your Boyle case, God forbid, same thing happened today. Would there be a case for that?
There would not. No.
Still. That's why we got so much work to do, guys, in governmental immunity. We have so many other cases that folks that are, I think, just so emblematic of how bad this law is. And I just wanted to share with you real quick. We haven't done it yet. We're in the process of doing it. www.venfights.com. We're going to do an actual page or a section of our website that we're going to call Get in the Ring. We want you all to get in the ring with us here and start fighting governmental immunity. And I don't think people quite get how important it is to write their state representative and their state senator. And the majority of us, to be honest, don't even know who they are. But it's gonna be on our website. Check it out soon. We're gonna try to encourage everybody, and I'll even come up with kind of a draft letter, and then you can add whatever you want to add, where you write your state senator, you write your state representatives, and you tell them, we don't like where you're putting the government's interest above ours as people, and we think it's wrong. So we're going to get to that, and we're going to get to some other areas. Paul, one thing I did want to touch base with you, and Tommy and I are involved in the Midland flood case and that fiasco. Here we are going on 2 years later with no end in sight of that litigation. You're involved in the Grosse Pointe flooding.
Yep.
So real quick, how does, in a year ago?
The lawsuit was filed a year ago.
Okay.
The floods happened June of 21, so a year and a half ago.
What's governmental immunity doing to you in that case?
Well, there is an exception. We call it the sewer backup statute, okay? That allows you to sue whoever owns or controls the sewer system if there is a defect that was a substantial, sort of like the substantial cause of the flooding.
Right.
Okay, so you fight that fight. But instead of answering the complaint in the case, the GLEWA, Great Lakes Water Authority, City of Detroit Water Systems, and all the local systems filed a motion to dismiss the case,
right,
claiming there's no way we can be responsible under the statute because of the heavy rains. And we have a judge in Wayne County Circuit Court's had the motion now for a year, hasn't ruled.
Right.
We haven't done any discovery.
Right.
And they've said
no depositions.
nothing.
Right.
And they've said no matter what the judge does, we're going to appeal it.
Right.
So
don't
get too excited yet.
You're going to be sitting for 2 years. Tommy, you and I are like 2 years in the Midland flood, and explain why Midland flood has nothing to do with personal injury and a tort, because we knew the fucking fiasco if we did that, which I still think there's a tort there, but we pled around that. Why is governmental immunity not a factor to like what Paul's talking about in our Midland cases? What's our theory of recovery?
Well, there's a general theory that if you took a constitutional law class as a high school kid, the government cannot take property without due process of law.
Eminent domain?
Eminent domain, yep.
Okay.
And it's basically if they decide to run a road through your backyard, they have to pay you for the property they're taking with their backyard. There's a second theory that comes from that constitutional right, and that's called inverse condemnation.
Okay.
And so
what's that?
Inverse condemnation is when a governmental decision adversely affects a property owner, then the government has in essence destroyed that person's property without due process of law.
Right.
And in the Midland flooding cases, there is just a bounty of evidence demonstrating that the state had control over several factors that led to the flooding.
Right.
And through decisions that they made, they destroyed these people's property.
Right.
Okay. And so that's where we've gone with that case. And that's not a taking case. A condemnation case is not something that's supposed to come within the definition of governmental immunity.
Right.
It's
not a tort. It's not a personal injury.
It's a constitutional right you're enforcing. But in our case, the government's taking the position that this is governmental immunity. We want the case appealed. We want it held up for 2 or 3 years.
Chris is shaking
crazy.
his head because you're arguing against that as we speak.
Yeah, that's right.
But Tommy, straight up, but for Michigan state governmental immunity law being so fucking bad, would we have allegations of a tort in our lawsuits?
Oh, sure.
I would have.
They were negligent.
Right?
Yeah, they were
so
negligent.
this is where I'm trying to get to, where so many people, right, everywhere I go in Michigan, they still want to hear about, tell me what's going on in Midland, because it's been forever and nothing, right? Like year 7.5, by the way, of Flint Water. And interesting that Midland flood, we're kind of following that same type of law, Tommy. You talked about Flint Water. That's kind of how they got around the governmental immunity there too. But what people don't get is we have to do all these like freaking gymnastics, you guys, to try to get around this evil, crooked law that shouldn't be, to me, right? But all right, well, so much for the road defect exceptions. Talking about our Moser, Champine, and Boyle cases. Thank you, guys. We're going to wrap up episode 23, Governmental Immunity Protecting the Guilty. Next time, Paul, you're deep into the Grosse Pointe flooding. Tommy and I are to our knees up in the Midland flooding, and guess who gets all of that flooding thrown on his desk but Chris Desmond. So we'll come back. We're going to talk about that next time. And also, we're going to get into some more case-specific examples of governmental immunity and how it's worked and really how it's screwed our clients in over the course of these years. And we might even have a couple suggestions and answers. We'll ask Tom Waun.
We'll have a lot.
We'll have a lot of answers. So
All the good stuff.
Stay tuned. If I don't talk to you, happy holidays. Be safe for everybody. We'll see you soon. Go Fighters, go.